I guess what I'd like to talk to you a little bit about is what is pending in court now on appeal, okay? We have, of course, we have the two Doe decisions that, were successful in the highest court. And one good thing that has happened since those two decisions, besides the removal of many folks, the state was taking the position early on that the only people that were going to be removed were those who, like Doe, who committed an offense before October 1, 1995, when the registry came into existence. So with a lot of fighting back and forth without being in court, I've finally convinced the state that the Doe decision does not apply solely to people in that position, because there's a footnote in Doe 1, not Doe 2, but Doe 1. There's a footnote number 9, which says that they are addressing not only the 2009 and 2010 amendments, but also the 2001 amendments that were made to the law. And that's important because it affects a lot of people. So if your offense was committed before 2001, not just 1995, the Doe decision applies to you as well, because you cannot apply the 2001, 9, or 10 law retroactively, okay? Now, we still are having a category of folks in our lawsuit that we are underway trying to pick the right plaintiffs for. I am still having a category that involves people whose offenses were even before 2001. And the reason is this, that I don't take the state at its word. Now, they've removed several people that have come to me as private lawyer. They've removed them that fall into that category. But I'm not so clear that they're going to do it across the board. The other thing I'm not clear about is precisely who they're removing. So what I plan to do next week, early next week, is I'm going to file a Maryland Public Information Act request. And I'm asking them to give me the parameters that they are using in determining who they're removing. And I want to know who has been removed. And they can tell me that because it's a matter of public record, obviously. And I want to know who they plan to remove, who falls into their categories. Because right now we're at a point where I really, other than the pre-1995 folks, I have no idea who they're removing. Because, unless they email me and say this private, client of mine has been removed, that's about all I can say, all I know. Or a member of FAIR tells me they've been removed, and that's wonderful, but I still don't know how it is they're making their decision on who they should remove, because I've had so many different categories that they've not removed and will remove. So it's just, to me, it's just too loosey-goosey is how I put it. So I am trying to, and I will be pinning them down. They have 30 days after I file the request to respond to it. And they can respond in one of different ways. They can respond by giving me the information. They can respond and say that I'm not privy to that information, but that would be wrong because there's no legal reason why they cannot give it to me. It's not like it's a personnel record where they can't provide that under the MPIA. Or they can say, we need a little more time to gather that information and give it to you, in which case, I'll say, okay, fine, you got another 30 days. Or they can say, we're not giving you anything, in which case I'll go into court and challenge them because there's a whole proceeding you go through under the MPIA when they refuse to give you any information. But it seems to me that the very least that we're entitled to is to know what their basis for removal is they're relying on, because there are, as you know, a lot of different categories of folks, not just pre-1995. So I'll be doing that next week, but what that brings me to is the lawsuit, okay? The lawsuit that Brenda has been actively seeking the plaintiffs for will fall into 4 categories. One is those who, even though your offense may have occurred after 1995, but it occurred at a time when you were required to register for 10 years, and then it was upped to life, or, they put you in a different category. So anybody whose term was increased as a result of the change in the law is going to be covered by the lawsuit. Anyone, and this includes federal offenses. There was a time when I wasn't sure that the folks who had federal convictions, that we could really cover them. But I'm becoming more and more convinced that we can, and that's based on Doe 2, which I'm not going to go into a lot of detail on, but I think the winning Doe 2 has allowed us to put the federal convictions in that category as well now. We are also going to have a category of plaintiffs who, even though you are lawfully on the registry, but the changes in the law have added more restrictions to you. For instance, a lot of the changes were made in 2001, 9, and 10, which, for instance, requires you to report your email addresses, requires you to report any chat rooms you belong to or your computer and all that kind of information, which was not required before those changes in the law. The frequency with which you report, either annually, and now it's every 3 months. All of those, we're going to challenge people who fall into that category whose restrictions have increased because of the changes in the law, okay? So that's not getting you off the registry. That won't get that category off the registry, but it will lessen the burden and the restrictions that you have, okay? And then the other category is
there was the pre-95. We were continuing.
We're going to still ask for that. And the reason for that is because, as I say, the state is not forthcoming. So I don't know who they're removing and who they will not remove. And honestly, and through the MPIA request, I made an MPIA request last year asking for everybody that's on the registry. And they did give, I do have a master list of everybody that's on the registry. And so what I want to get from their parameters is now I can compare it to the list that I have to make sure those folks have been taken off, who are supposed to be taken off. Because right now I don't know if they have or not. And so those, we're still going to cover any Doe people in this lawsuit as well. So those.
I do know the other category was the group that was not originally on at all, or had
fourth-degree sex offense and misdemeanor child pornography. When those, there was a time when those were not offenses for which one had to register, and then the change in the law added them. So that's the other category. Yeah. And it's not just those 2 crimes, because there may be more, but those are the ones that just come to mind right now. But anybody who was added because your offense was later added to the requirement that you register. So those are the 4 categories. And I think that pretty much covers everybody that we believe that the Doe decisions apply to. So as I said, Brenda has been gathering the information on those that want to volunteer, and it has to be by volunteer for this reason, that while I will ask the court that you be designated as John or Jane Doe, that's not guaranteed. The court can deny that request. They have not denied it yet for me, but it's a possibility. They can say, no, we're not, you got to use your name. So obviously we want only volunteers who understand that and are still willing to move forward in case that does happen. And I think Brenda does have volunteers. A lot of folks have volunteered, and I greatly appreciate that. So what we're going to do, and Brenda has given me a lot of the information, and she's going to send it to me by PDF as well. I will then, with my paralegal, we're going to go through that list of people, and we will contact you and sit down and talk to you to make sure you understand what you're getting into, and you know, you're good with that. And then we will start with the actual litigation, filing the complaint. An interesting question was asked of me by Brenda early this morning, or earlier this afternoon, and quite honestly, I don't know the answer right now, but I'll find it for you probably when I go home, when I do a little research. And that is whether or not you, as the plaintiff, have to be in court. My gut says no, you don't have to be in court, because as the lawyer, I represent the class of plaintiffs, so it's very different, and it's a civil case, so it's very different from a criminal matter where the defendant has to be in court, okay? You can't do anything without the defendant being in court, but I don't think that's true in a civil matter. So I will definitely find out the answer to that and send it to Brenda, and she can blast it out on the website, so that those who are thinking of volunteering, if that was of concern to you, will have the answer for that as well. So that's really where we are right now. We're very close now to actually honing down who it is that is going to be a plaintiff in each of these categories for us. And then we're just going to file the complaint. I've been working on it already. File the complaint, and I'm probably going to file it in Baltimore City. I'm still playing with where exactly I want to file it, because we want to obviously file it where we think we have the best chance of winning. And I've won a lot of declaratory judgment actions in Baltimore City, surprisingly. So that may be where we want to do this. The other case that is pending on appeal that I gave Brenda the actual finding of the circuit court in the case. And the gentleman who was my client in this case doesn't mind that his name is being used, but his name is Ronald Alston. And Mr. Alston was in the category of his time on the registry was increased from 10 to life. And I filed a declaratory judgment on his behalf maybe, I don't know, a year ago or a little less than that in Anne Arundel County Circuit Court. And I won, and the state appealed that case. So where it is right now is we are waiting for the briefing notice from the Court of Special Appeals in that case to say when the briefs are due. That's all we have. So what I've given Brenda that she can put out on the website is the actual ruling by the circuit court, which is, it's interesting to read, but it ultimately comes down our way. So I don't know if the state is going to continue with that appeal. And the reason is because at the time of that appeal, they did not believe Doe applied to 2001 amendments, and I've since corrected them about that. So I don't know, they may wind up dismissing the appeal, but stay tuned because I'll keep you up to date on how that appeal goes. And as far as I'm aware, there aren't any other cases on appeal that affect these categories that are, you know, in the works that I know of. It seems to me that I seem to be the only lawyer that's filing these things, and I've got a lot of them filed, a lot of them, but they're all in these categories. There's nothing, you know, that will not be covered ultimately by the lawsuit, which hopefully once and for all we'll be able to settle who gets off, who stays on, and who gets what restrictions applied to them. So that's where my work on this stands. Does anybody have any questions for me about that, Robin?
Okay.
Anything, I guess.
Hang on.
Well,
Even though somebody's still on the registry, that certain criteria could be ordered removed from them. And I just wanted to bring up, I think it's very important, even if somebody has to stay on the registry, if the employer can be removed, that's a very important thing to remove.
That's a good question. And from what I recall, and I've read the statutes from 95 on so much, prior to 2001, and when it was initially, the registry was initially created, that information was not required. It was your name, your address. I don't know that there was much more. But I will, find out at what point they did include the employer. And of course, your car was not required, your license number, or none of that was required. Your fingerprints weren't required, your picture wasn't required. It was very basic information. And in fact, it wasn't until 1999 that it was required to be put on the internet. So there are some folks who, it may be possible, and I'm still working on this argument to see if it's a plausible argument, that some folks should, even if they're on the registry, should not be on the internet. So there, as you can tell, there are a lot of permutations of from the changes in the laws that we could possibly argue.
The state doesn't have a guaranteed appeal as when you are sentenced in court. You can appeal. Mm-hmm. Am I correct that the court could turn down their appeals?
No. In criminal matters, the state has a very limited right of appeal. It's extremely limited. For the most part, they can't appeal. In civil matters, they can. They have the absolute right, a direct appeal. So that they're correctly in court. Well, I would tell you that I do have a client right now who he is on the registry, but he happens also to be on probation right now. And he lives in Ocean Pines. And he has been told by his probation agent that he cannot go to Ocean City because they're especially in the summer. And he has he banks in Ocean City. She's told him to get a different bank. So I'm chomping at the bit to get at them on this one too. So, because you just can't, she can't do that. And so anybody that's on probation who also happens to be on the registry and they're ordering you to do, stay away from here or go there, just tell me, because I have the perfect case to argue against them.
Yeah, Nancy, who has that authority, or where does that authority come from that for the public defenders, the public safety, to ignore the declarations of the court? Well,
they don't see it as they're ignoring it. They are interpreting the decision of the court, as they think it applies. So it's not like they think they're doing anything illegal and just don't care. Their interpretation of the case is not as broad as ours. So that's why it requires challenging it in court and getting it resolved once and for all. Who's right, them or us? So I do think they're doing this in good faith. Honestly, I know the attorneys on the other side. We disagree vehemently, but it's all in good faith, their argument. Here's where the attorneys that I'm dealing with get their marching orders from, and it's from Mr. Gansler, who, of course, is the Attorney General, who at the time, of course, was running for governor. But there's something, there's something to look forward to, if you will. The next Attorney General, I believe, is going to be Brian Frosch, because his contender is not known very well. Brian and I are on very friendly terms, and he is one of the most reasonable, smart, and obviously an attorney who cares a lot about doing the right thing, even if it, annoys some people in Annapolis. And so the first thing I plan to do, I've already planted the seeds with him at various functions that we've been together on, that I want to sit down with him once the election is over and try and, come at it from the legal angle, the human angle, and say, can't we just reach an agreement that Doe and Doe 1 and Doe 2 apply to these categories of folks? And hopefully, and I do trust him implicitly. I'll be very honest with you. Now, he is a politician, of course. There's no getting around that. But he is a really dedicated person who cares about the right thing. So I'm very hopeful that after the election, and I can sit down with him and explain things to him, even while the lawsuit is going on, maybe he'll back off, get them to back off a little bit.
That would be wonderful. I will also, that's the only political thing I'll probably say all day, but that I've also talked with Brian Frosch. He's currently the chair of the Judiciary Committee. And so, again, he's political, so there's an angle, but he does get our issue. Whether or not he can, how much of a public stand he'll take on it remains to be seen, but he will understand and try to work with us in whatever way he can, I think. Yeah.
Well, they didn't know it was unconstitutional, and here's the
told them.
reason, because,
We stood right there and told them.
well, I know, but
What do we know?
what they were relying on is at the time when a lot of these laws were passed, Attorney General Gansler was asked to examine the constitutionality of these laws, and he wrote up an Attorney General opinion telling them that this was constitutional. So they were operating on what they were being told by the AG. But in any event, I will tell you this much about Brian is that, or Senator Frosch, I should say. His father was also an attorney, and he proudly talks about the fact that his father was, he represented those that were brought before the McCarthy, whatever they were called at that time, board, where they were accusing people of being communists. And his father took the stand that a lot of people told him, don't do it, it'll ruin your career. And he proudly talks about that. So he gets it, is really what I'm saying. He really does get it. So I'm very hopeful.
Just a quick one, to add more complication, what about out-of-state convictions as far as what you're doing?
I've gotten them removed.
Mm-hmm.
Mm-hmm.
Yeah.
Yes.
I mean, if you, what I've been telling people, correct me if I'm wrong, is that if you're out of state, your conviction was out of state, but if you were here and registering, and Maryland has changed your registration retroactively, you qualify.
Mm-hmm.
Well, like a 1994 conviction.
Right. Yeah. Whether or not the fact that it's 94 might be an issue, I don't know, but I'm not.
Yeah, no, I mean, I literally just recently had somebody removed under Doe whose conviction was from Texas.
Does the 2010, you keep referencing that, that was, if the crime was committed before 2010 or end 2010, wasn't it Jessica's law that changed it and made it retroactive?
Well, literally, Maryland made its law retroactive in 2001. That's when but it was to a very limited category of dates. So in 2010 is when fourth degree was added.
In August or so.
October 1.
October 1st.
It's always October 1, almost always. So the law was made retroactive in Maryland in October 1, 2001 to a very limited category of time frames of when you were convicted. And then in 2010 is when they just said, everybody, it goes all the way back. We don't care when it happened. So that's why
They did that some in 09 too, didn't they?
and a few in 09, but the major lump was in 2010. So the Doe 1 says the 2001, 9, and 10 amendments cannot be applied retroactively. Yeah, most people thought it was only the 09 and 10, but look at footnote 9, and it says we're talking about 01, 9, and 10.
Okay, so if we needed to get somebody's name off the list that would apply to, we'd have to come to you as an attorney?
Well, here, no, see,
That's what we're doing.
FAIR has hired me for this lawsuit. Now, when I'm referring to other folks, these are private clients that came to me, long before all of this. Or that come to me now and don't want to wait for a lawsuit. But I want it to go into this, lawsuit so we can once and for all not do things piecemeal and just get it all taken care of as quickly as we can and as comprehensively.
Yeah, we have one question way back there.
Hi, I wanted to find out if you knew of anyone that was had a quorum nobis pending before the court, if there's any successful ones, if there were any current ones, or what your opinion is.
Quorum nobis for what? To get off the registry?
The registry based on, at the time of your conviction, not being advised of the registration requirement at all.
Actually, I was able to get, I filed a quorum nobis in Anne Arundel County for a member, one of our members, a while, maybe 8 months or so ago, based on the collateral consequence of having to be on the registry when his guilty plea to the registrable offense was not voluntary, and I won. So yes, there is.
A case
Well, I won, and the state didn't appeal, so there's no, you know what I'm saying? There is a case that was successful, but, you know, it depends on what jurisdiction you're going to be in. But that certainly is a viable argument, yes.
There's the big picture and trying to settle it all once and for all. And then there is the sort of desperate urgency because a day on the registry is a lifetime. And if you're a young person and you're trying to have a life, every one of those days matters. Of course. So realistically, I mean, is it, when I hear, you know, other people who did it privately and now they're off, which is the right way to go? I mean,
I do understand, and when clients call me, and you know, I always say, this is the option. I say, if you want to wait and be a part of this lawsuit, which, you know, it's much more comprehensive, that's your decision. But if you can't wait and you want it now, then hire an attorney to get, you know, do a declaratory judgment action for you. And I'll be honest with you, and Brenda knows this, that a lot of folks have done that with me and said, I just can't wait. And a lot of times in those cases, it doesn't even take filing a declaratory judgment. It takes preparing it, and I deal one-on-one with the Attorney General's office, and I email it to him, and I say, look, do you agree with me that this person doesn't belong on the registry? If you do, I won't file this. If you don't, then we're going to court. And I would guess that at least 95% of them, they agree with me, and we never go to court. And they just take them off. And of course, those are the obvious ones. You know, folks who are really dough, you got something pre-1995, where you're just now waiting for the state to get around to you. You can quicken the pace by getting a declaratory judgment drawn up. So I'm being honest with you that it's a question of, do you want to be patient or not? I mean, that's really what it comes down to. But I don't want, at the same time, to discourage having plaintiffs for this lawsuit. If we manage to have enough plaintiffs to, you know, fit in these categories to go forward, and those that are covered by this but are not the literal plaintiffs, you know, if you want to go and do it privately, then that's fine. But I think it's really important that we have people to be a part of this law.
there's 884 people registered with FAIR. There's nowhere near 884 people here today. There are people who complain and complain and complain and complain, but, you know, I can't put my name out there. Well, your name's already out there, so I don't know what the problem is. And, you know, at the end, sometimes I feel like there's a small group of people who are going to do the heavy lifting in terms of putting your names out there and funding it and whatever, and waiting, just the plain waiting. And I hate to sound selfish, but it's 9 years down the road and I'm so over the whole thing. And
Here's what I can tell you in all honesty. I believe that if you are in the category where your offense occurred before 1995, okay, or if you are in the category where it was not a registrable offense at the time that it was committed, and I'm just going to be honest, you should go have a declaratory judgment done, because those people are being removed. And if you want to speed it up, that's what you should do. The folks in these other categories where your time was increased, your restrictions were increased, it's a federal offense, because that has not really been litigated as it's a federal offense. If you're in those categories, this lawsuit is going to benefit you the most.
That includes the 10-year to longer term as well?
Yes.
Because
yes.
that's not as clear
Well,
with no.
Correct. That's not as clear. It's the people whose time was increased, the people whose restrictions were increased, and have federal offenses that are going to benefit most by this lawsuit. The folks who are pre-1995 offense, or your offense was not one for which you were required to register at the time it was committed, you are ultimately going to be removed by the state. When? I have no clue. So if you want to hurry it up, go and get a declaratory judgment done, because that pushes you to the top of the state's list.
unless it was a non-registrable but federal offense, in which case you're probably better off going with the lawsuit.
Yeah, the federal aspect has to go into the lawsuit because the state won't concede that yet.
Yeah.
But the other two categories, the state concedes, they have to take you off the list. But they're doing it at their good old time. And so I've found that if you want to move to the top of that list with the state and get it in their face and say, get me off the registry, you can only do it by a declaratory judgment.
Here's a question that ties in, I think, with the time, the time that it's taking. At this point, we're starting. I mean, we're not waiting around for any more decisions. We're not waiting around for anything else. So realistically, what's a time frame we're looking at with this challenge as far as moving towards decision?
Well, we have the plaintiffs or potential plaintiffs.
Potential plaintiffs.
I would say, where are we? We're in November. I think something could be filed by December.
Okay.
Well, then, you have to wait for the state to respond, and then, they're going to ask for summary judgment. We're going to ask for summary judgment. If you want to know bottom line how long, I would be guessing, really, but maybe a year.
Okay. Because that's, sure. I mean, you never can be sure, and obviously, delaying tactics are a whole part of the process.
Right.
I've learned that, and it's frustrating, but that's the way it is.
Yeah.
But to get a ballpark.
That would be my guesstimate.
And doing it on your own in those categories would be the same. I mean, as opposed to the declaratory judgments you described of pre-95.
Yes.
Those could speed things up.
Correct.
But if you're doing a declaratory judgment in one of these categories, it'll take just as long
It'll
on
take
your
just
own
as long because the state has not conceded
with
these
that issue.
categories.
So it's just
They're
you're doing
gonna
it
fight
on,
it.
Yeah, you're doing it on your own and paying full price
Exactly.
for it rather than working with us and getting the same result.
Exactly.
So, okay, we got it.
Because I'm hearing off the record and on the record that a lot of the stolen tactics right now is politically motivated, and come November, things will go into frenzy removal. What's your feelings on that?
Don't believe it. Huh? Well, the thing is that I don't really believe that's what's holding anybody up, because there's, nothing to be gained politically by, stalling. I mean, the law isn't going to change, when Frosch comes into power, so there's no reason to stall. I just think the state's taking its good old time. They've told me, and the other thing I'd like to warn everybody, I know I see it on the FAIR website with everybody's, what do you call it?
The forum.
Forum, thank you. My probation agent told me this, and mine told me that. They don't know anything. I mean, I'm not trying to disparage them because they are hardworking folks, but they don't know anything. They're waiting to get it from on high, and they're guessing. When they look at your things and papers and say, well, you should be removed, just please don't, I think they mean well, they're well-intended perhaps, but they really don't know. And they're causing a lot of confusion because I keep getting all the calls from this jurisdiction and this one and this one. So what I would say to you is that in my opinion, the state, they have told me that what they are doing is reviewing every single case individually. They are getting the documents, the charging documents. They are contacting the victims. Why, I have no clue.
Yeah.
And that is holding things up. And they have no business, holding it up so that they can contact victims, okay? That's all this is about, is that slow-moving process where they have to go get these documents and then call victim or track down victims. So
Obviously, they get grant money from the federal government, per the Adam Walsh Act and other things, and for the number of registrants and when that is awarded, because that could, you're throwing out motivations, that could be a big motivation.
Well, it's, correct me if I'm wrong, because I don't know that part of it that well, but I don't think it's tied to the number of registrants you have. I think it's tied to, are your laws identical to the Adam Walsh Act?
And I'm not
Yeah,
Yeah.
it's not tied to the number of registrants.
There might be a connection, I'd have to
Yeah,
look
see,
at it.
I don't know.
I know it varies from state to state, so and in terms of how much is given, so there's something that they're basing the size on.
Well, I
but I'm
did,
not sure what it's based
in
on.
my brief in Doe, I can't, in the Doe one, I did do research on the amount of money, and it's in a footnote. I have to go back and look at it, because but I don't recall that it was tied to the number of registrants. Here's how I can envision the increased number of registrants being, profitable, is because you all have to pay fees for your, reporting, every time you report to go, and it sets up these sex offender management boards, and you got to pay them a fee. That's the only way I can really see that it's, yeah, you got to
That's
pay
their
everything, it seems.
Counties are paid per head. Yeah, so, but that's coming through the state.
Well, that's
And it's
very
not
interesting.
directly connected with burn grants. so.
Their portion of the burn funds is based on the number of registrants that you have in your county, and that money is filtered down to the department for administrative stuff, and also for actual officers to go out and make these ludicrous.
And if it goes over the actual,
They have to pay it themselves.
they have to pay it themselves, right?
Yeah, and it's only like, and I say only, but it's only like $100 a person. And they're spending more than that now to do all these address verifications and all that stuff.
Added to it.
Yeah, yeah. So we're paying way more than we're getting in burn grant money.
I just wanted to address what you said about should we wait or should we, go on our own. I benefited from Nancy's first case, and I came off the registry, and I'm not registered right now. I had a declaratory judgment filed, and I came off July 1st. However, it's only because of Nancy's work that I was able to get the benefit of that. Somehow, if you want to do it on your own, that's great, but we've still got to support what's going on right now. And financially, or as a plaintiff, or whatever it is, to protect what's going to happen in the future, to make sure that we stay off. So I don't know how to tell you, declaratory judgment worked for me, but somehow we've still got to be here to support the new case, the plaintiffs, and financially, and whatever we can. And I'll admit I haven't put any money towards this new suit, and I'm not registered right now. But I will look into what I need to do to help, and it may not be much, but still, whatever it is, it's not over.
No, I absolutely agree with you.
Yeah, I would
And-
say do both, is what I'm saying.
Basically, you did both.
Yeah,
I
I'm
mean,
doing both.
you benefited from her previous work, but then you went and got a declaratory judgment. I'm in. I mean, but of the 888 people, $20 a month, $5 a month. More people need to be saying this matters, and because you're right, it's not going to be over. Even when this is done, it's not going to be over.
No.
And I think it's discouraging to me sometimes that there's 6 people who even bothered to check in on the forum. Where are the other 882? There's too many people who say, well, I can't because it's hurt my ability to make a living, duh. I can't because I can't have my name out there because of my family, another big duh. Your name is already out there, and it's not going to get better until you do something to make it better.
I will insert here that we have quite a few more people who are giving than are talking. The last campaign that we've done, I should have said at the beginning, this last campaign, we've had a really good response, and we have, I'd say, 70 people who've contributed. So it's not just 6. There are 70 folks. And the people who've been sending in small amounts have added up to $6,000 in the last just in the last few weeks. We have pledges of several thousand more that'll be coming in the next month or two. So, and that's just this campaign. So we have people who aren't comfortable stepping out, but they have been putting forth, shall we say.
Stand in front of Walmart with a little thing.
Stand in front of, yeah, that's right. We can say, hey, help the sex offenders, ding, 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 ding.
Right.
I'm not sure about that one. Yeah, and some of this, the other, Yeah, and the other thing, you're working
Oh, my
well.
God.
Yeah, the other thing to keep in mind too, I think, is, we've been so focused on this challenge that we do need to remember that there's also a sizable group of people that are still screwed.
Yeah.
I mean, this is not going to help the people who've just come on. Aaron, bless his heart, is over here with a fairly recent, none of this is directly impacting him. We have, and so some of this money that's coming in, if Nancy needs it because the case drags on, then it'll be there for her. But, we may need it going into legislative session.
Yeah, that's more
because
important.
we'll end up with somebody out there trying to close these dreadful loopholes that we've just created. So we're going to be ready for that, and people are putting forth that money for that reason. And we're also hoping that with the coming legislative session, we've got a couple of folks talking about actually trying to take advantage of this situation to produce some new legislation to talk about, maybe we really ought to have a way to get people off after a certain period of time. Whether or not we've got the political will to go that far, I don't know. But anybody who's in Tier 1 does not have to be public, and you can still be compliant with Adam Walsh. A lot of people don't know that. Delaware doesn't put Tier 1s on the list. So there's some things that we could do. We just need to put it out there. But we might just try. I mean, what harm could it be to say, hey, look, don't you think that after 15 years or 10 years or whatever, no matter what the original crime was, since we've declared it punishment, don't you think that if it's punishment, that somebody should be able to appeal to say that they're done being punished, they don't need to be punished anymore? So maybe we could work on a removal process. It'll be a long-term thing. It won't happen. I mean, even if we manage to get the darn thing introduced, it won't happen. But it's something we have to work on.
I had a technical question. When you said for the people that do go it alone, the threat of the declaratory judgment is just enough to get people removed. You hit the nail on the head in my case, because that's what happened. But
did I represent you?
no, not on that one. My attorney withdrew the declaratory judgment with the option to renew it if for any reason they put me back on or who knows what. I didn't understand the value in doing it because we already won. So why not go to court? Why not get the judge to sign and say, yeah, and go forward all the way? And even if the state agrees, and why is it a mutual walk away at that point? Why not take it to the end and get the judge's order?
Because once the state agrees, they're not going to go back on that. And to be honest with you, what I tell all my clients is it saves you money. If you want me to go to court, it's going to cost you a lot more money. And so if I can do it without having to go to court and you can rely on the word of the state, which you can, because of course we get it in writing.
The thing that I'm stressing with the legislative effort is where we have to watch, because that's how you went from not having to register to 10 years to 25 is through the legislature.
Right.
And because the legislature up until now was saying, well, it's a regulatory scheme. We have the right to make these changes, and we can make them retroactive because it's not punishment. So we can do that. Now we have a Supreme Court decision, as we call, the Court of Appeals decision that says it's punishment. So they can't say that anymore. They can still try to do other stuff. They can still try to screw us over, and that's why we have to be careful. But but they can no longer come in and say, well, we can add this and we can throw these people on that weren't on it before. They can't do that anymore without taking it to court. But we cannot sit back on our laurels and say that. That's why we have to continue to watch what gets introduced. We have to continue to pay attention to what's going on in Annapolis. We can't sit back, even if we get off, and assume that they're not going to try to come up with something.
Well, in fact, I've heard on the news and I've read in the paper where some legislators were so angry at both Doe decisions that they're vowing to fix it in the next legislative session. And I've had a lot of calls from people saying, oh my God, what are they going to do? Well, let them mouth off as much as they want. There's nothing they can do unless they change the Constitution of Maryland, and the only way they can do that is by putting it out to vote on a,
On a referendum.
Right, a
And
referendum.
we don't want that referendum,
And,
obviously.
it's just, it's not going to happen. It's just
Yeah.
not going to happen. Senator Brochin, who's my senator, was one, which made me happy. Because he came to my door, they go to door, and he knows who I am, and he was not happy when he saw me behind the door. But he's one that I know has been, mouthing off about that, and there are some other ones who, oh my God, from
Smeagol.
Cecil County, he's, yeah. Thank God.
I've heard that,
Thank
yes,
God.
Nancy Jacobs
Yeah.
is retiring, yeah.
She's awful. I mean, and in her political thinking, I don't mean as a human being, I just mean.
If someone has a current case pending, can they file a declaratory judgment?
Yes.
Okay? And whether they have a case pending or not, and they file a declaratory judgment and the state denies it, are they exempt from the class action suit?
No.
So it's sort of win-win. I mean, if you can't go street A, you go to street B.
Correct. Yes.
Thank you.
You're welcome.
Okay, yep. If you've been on our forum, you've probably heard. The issue of a person who is no longer under supervision, and yet the registry officials will come and do an address verification check and start requesting, not asking, requesting to come in, banging on doors, making threats, which we had one of our folks get just recently. The quick response, which we gave, of course, online, was they have no authority to do any of that. None. There's not even anything in the law, I believe. There's not even anything in the law that says they need to do an address verification check. Okay, this is just, no county has that in a law that says that somebody has to come to your door at all. So they're doing it because it makes the public happy.
Right.
But you have no obligation to open your door, to sign anything, and definitely not to let them in. None. What you do, of course, is up to you. If you've got a friendly relationship with your registry official and you want to invite them in for tea and cookies, that's fine. But if they're banging on your door and treating you like you just got out of jail last week, they have no authority to do any of that. And that did happen to one of our folks, I don't know if they're here today, from Baltimore County, who had an official do that. To just simply report the misconduct, as you know, you need to know your area, because Robbins is our favorite person for filing complaints. But and they don't like you when you do that.
Yeah.
You have to be willing to accept the fact that they're going to start labeling you as a troublemaker when you do it. So that's the other thing to consider. I don't recommend that. You want to file it if you can. Nancy, you may have more legally things to say, but.
No, I mean, the fact of the matter is they do not have the right to open your door and cross your threshold without a warrant. And you don't have to answer your door. I mean, that's just the bottom line, and they know it. They know what the law is. You get rogue cops, in lots of different areas that will do whatever they want anyway.
Yeah.
But you all know I mean, when I read the forum, I'm like, yes, you guys, you know the law, you know your rights. That's the most important thing. I tell all my clients that, know your rights, know what you can and cannot do. And that's about, and I guess the only other thing is, if you have a lawyer, call your lawyer and say, this is the name of the cop that did this, walked into my house, and let the lawyer take care of it.
I have one piece of advice I'd like to offer everybody in this room, and I think Nancy is basically concurring with what she's been saying. Don't be friendly with these. I mean, you can be courteous. Don't be friends. Don't invite them into your house.
Never,
If you
ever,
research, if you research on the internet, ACLU tells you, do not be friends with police. They come to your house for a reason. They're in business, and they're not there to be anybody's friend. It is not recommended that even if you're 100% innocent, that you invite police into your home.
And don't go off their property.
Yeah. Don't lose
Because
your
if you
property.
lose a lot of rights.
You lose your rights when you.
You sure do.
You are allowed to go and vote on school property on Election Day. They've tried to change that, but.
North Carolina.
Yeah, if you're illegal, that's another issue. But, yeah, if you have full rights to walk on there, onto school property to vote on Election Day. And you have full rights to vote. I usually manage to mention that at least once every meeting, because there's always somebody who says, oh, I didn't know that.
Nice.
So I think most of you have been at meetings to know that. If you're done with supervision, you can vote. If you're wanting to be a plaintiff, there's 3 documents we're trying to collect ahead of time. The one is the
Charging document?
document.
Which will be usually an indictment, it's called, or a statement of probable cause. It varies, depending on what you were charged
And then
with.
there's the probation or release document where they
It'll be called, if you're on probation, it'll say the probationary order.
Or it might say conditions of supervised release.
right.
That's
something to do with
federal. It'll be
supervising.
conditions of supervised release, which is attached to a sentencing order. And I think that.
The registration, if you've got your initial registration requirement that you sign, not everybody held on to those. And sometimes you can find them in your court docs, and I've had other people that have had a real hard time with that to locate them. But that's the other thing.
That one's not as critical, though, really, the first registration.
Okay.
It's really the charging document and the sentencing order that's most important.
Yeah.
What I'm looking for, that I have to have in order to know that you fit in a category is, which is the date the offense occurred, not your conviction, okay? It's the date the actual offense occurred, and that's why the charging document is critical, because that will list the exact date that because sometimes the charge is the act occurred between January of 2000 or January of 1995 through January of 2000. But when you get to the actual charging document, it will usually hone in on what the precise date is. And that's what I really need. And then the sentence that was received.